22(1) of the Constitution gives the right to the people of Seychelles and people generally here access to information and the right to receive and impart ideas. It's a fundamental right. Article 19(1), on the other hand, creates a right to fair hearing. That is, somebody has to be tried, prosecuted before a tribunal that is independent, impartial, and public. So the rule is all judicial determinations has to be done publicly. So our courts are open forums, be it tribunals, magistrate court, or Supreme Court, Court of Appeal, all the forums. So how do we marry these two? Right to information and right to have access to a public judicial determination. Usually the citizens of Seychelles have no time. They are preoccupied with their daily businesses. And unless they watch the 8 p.m. news at night, they are totally unaware of what is happening at court. We have a few individuals that come here to watch cases, but they are in the minority. So how do they receive those information, which is out there in the public interest, but delivered by a court which is open and impartial? It is through the media houses. It is through you. You are the persons who take those information, public interest information, and brings it to the homes, to the 7 p.m., 8 p.m. news. So that's why you are important, and that's why you are here today on this occasion. And obviously, it's not an absolute right. It's a right that is limited by law, reasonably justifiable in a democratic society, in the interest of others. For example, you cannot print out, publish anything on anybody because you have this right. There's a law of defamation that prevents you from doing it. We have vulnerable witnesses who sometimes testify before our court because of their young age or the content of the proceedings. You cannot go out and reproduce it out there. The court would say no. You have the decorum of the court. The court has a decorum. It has a certain sanctity in it. You just cannot come in and say whatever you want and operate in whatever manner you want. You have the court, the dignity of the court, credibility of the judges to protect. So, given the issues that arose in those contexts, I have decided to issue a media access practice direction, which can be made available to you physically and through our website, and also on SEALI, if I'm not mistaken. The whole idea of this practice direction number 1 of 2021 is to ensure and solidify this partnership between ourselves and the media. Based on the principles under the Constitution, we have said that the court is open to audio, video recordings. So anytime a journalist wants to step in a court and audio record or video record, that the rule is there. However, the judicial officer has a discretion on a case-to-case basis. So he needs to know beforehand if the SBC is coming this morning to film a certain proceedings, so that the proceeding is not disrupted by the fact that there are journalists inside actively filming the proceedings. The court needs to know, because this is a sexual assault cases in which there's a vulnerable witness and the law is protecting that witness. The court needs to know because this is a case involving trade secrets. This is a case in which the court has issued direction limiting the right of access to the proceedings of the court. So the court needs to know, and if it's a case which is straightforward, there's no limitations under the law and the Constitution, you will have access to the court for actually filming, but maybe on a limited basis, not for the whole proceedings. But as for sitting back and taking notes as a journalist, the traditional way of doing it, that obviously I don't think there's a need for the court's permission, except if it's a closed session or it's a restricted session, and you will need to inform the court, because if it is restricted and you don't know and you come to publish it, then you'll end up being in contempt of court. So the role of the judicial officer is to allow journalists free reporting subject to these limitations. As to live text we've seen, for example, this session of the last session of opening of the Supreme Court was live. That also falls within this category. And also we have our public relations officer, Ms. Sasha, who is known to all of you here, and her duty is to act as a liaison officer between the court and the media houses. For example, one thing she will inform you is that once you get a judgment, that judgment cannot be edited. It is as is. It has to be edited by the court. If for some reason the name of vulnerable witnesses has to be struck out because she's an infant, this is done by the court. But you cannot go into the content and turn that judgment into your own, because the right, copyright lies with the judiciary, and it's an offense to alter a judicial determination. So in order to facilitate accurate judicial reporting, which we also have introduced, and it's there under 11 in the practice direction, which is to make available summary of the judgments or ruling, which is done by the court together with the PRO officer. This facilitates the reporting, because many times we cannot produce the judgment on the same day. There are typos, there are certain grammatical errors which needs to be corrected. So a fair and accurate summary of the judgment can be given to you for purpose of reporting. All access to the judiciary, media, should be done through the public relations officer. So all requests for judgments, court rulings, all communications, she is our route to you. And we will make a copy available to you. You can, before they leave, you can make them available. One thing, and this has happened in the past, which I want to caution you, is we judges, we speak through our judgments. We are not in the business of giving interviews on our judgment. I've seen that it has happened that journalist has come to the judiciary and see what that person wants to have an interview with a judge on the reason of his judgment. This is never done. So the judgment speaks for itself. You can scrutinize it, you can look at the ratio decidendi, you can comment on it, but it is self-explainable. It explains itself. There's no need for further explanation. If a person contests a judgment, he goes to a court of appeal or a higher court for contest. But there's no obligation and there's no duty in law for the judge to comment. And in fact, in this practice direction, I've made a specific direction that no judges, including myself, should be making pronouncement on a pending judicial determination. A pending judicial determination. Because this is sub judice. If you comment on a pending determination, the witnesses have not testified, or they are under testimony, you are going to either affect the substance of the testimony or the determination itself. And also, another word of caution, there's a way to criticize a judge. You can criticize a judge. We are open to judicial scrutiny, but there's a limit to it. Unless there's hard proof of bias, conflict of interest, then you cannot say that the judge has ruled in such a way because he is unduly influenced by a political party, by a politician, by a family interest. That's a criminal offense under the penal code. To make adverse and undue, unsupported allegations of corruption, biasness against a judicial officer when there is none that can be proved. So this is a breakdown of our new practice direction, which will be made available to you. As I've said, it is there to support and strengthen our partnership because we were a bit in the dark before this happened. We were unaware, and you were unaware of the different rights and limitations to access to the judiciary. Thank you.